Make it.
Item number 18, my lord, waiting for all the respondents here.
Yes.
Make a joint prayer, my lord, for listing it in the month of January, my lord.
18 is a hearing matter.
Hearing matter.
On a joint request made on behalf of the parties, matter is adjourned to be listed in January 2025.
I'm appearing for special PP Niyamat. My name is.
Can you write both the names? Sri. Your name is also not there?
My lord, I'll be appearing on behalf of.
Okay. You appear as special PP.
My lord, I'm Pukan special.
And I is present. Huh?
Niyamat.
Okay.
Master.
Pleasure.
Okay, I take to the listing of a matter or orders.
Fresh matter.
Fresh matter, not fresh matters.
Appeal of which year?
Appeal of 2023, but the petitioner has been in jail for a long time.
Okay. Paper book prepared.
Yes, sir.
Okay, but have it in the next week? Next Friday.
To come for orders because
Next Friday for orders.
I didn't want.
Okay. Boxos. Admit something for from jail. नाम लिख दीबा के दास informant victim Poxol informant / victim yet a party nine to be processed through the hearing office of the PP 6 weeks for record as well as receipt of service. Arami Amicus as an appointed podium. Yes, madam, it would appear as amicus. Mohebura. Yes, Mohebura. 28. Huh?
Okay. I didn't do.
302. 302. It was second part 2, no? PK Das. 302 to DJ Herit. Joshua Das, number 3. Yes. বক্স আছে হ্যাঁ এইটো 3 দি দিবি অনুপ মৃণাল দত্ত 32 বক্স আছে দে বক্স হলে victim informant to the office of the PP service. POCSO আছে। POCSO একটু নেব। এটা হবে, অঞ্জন কলিতা 5
I think five.
POCSO আছে এটা। Thirty-eight, 38 numbers. 38 okay. Amicus. Okay, এটা POCSO আছে, হ্যাঁ?
Six.
এটা 302 of all. 302 এটা POCSO নয়, হ্যাঁ? Private respondent নয় এটা। Thirty-six Myanmar Catalonia. Okay.
Item 20, sublease.
May I please, my lord?
Yeah,
My lord,
sir,
can this
Mr.
matter
Verma.
be taken after some time? As the news on like
Item number?
20, supplement.
Okay, after some time.
I would like.
Item 7.
This is on appeal preferred by the state of Assam, I know. Process due to some communication gap, I did not take place states on the response. Although it was served earlier, but in terms of. one
In
of
the leave
books of-
application.
Leave application. No, I will be
If-
given 1 week time. This is the POCSO matter, my lord.
Okay.
Notice has to be served on that.
In the office note dated 6/10/2023. Long time. Whereby fresh steps, whereby it has been reflected that fresh steps have not been taken. Para? Ms. Bibb here, learned APP, however submits that due to some inadvertence, steps could not be taken for service of notice upon the sole respondent.
It was once taken,
Fresh,
put in.
fresh, we have said. Full stop, para. Say accordingly prays for and is granted further time of a week to take fresh steps. List after 6 weeks along with for report on service.
Item 8.
But
Yes.
in this case, also LCR received, so the registry will be directed to prepare the paperwork.
LCA received.
Conviction under section 37.
Records have been received. Para, let the paper book be prepared and the matter be thereafter listed for orders to fix a date of hearing.
Public.
Item 9.
My opinion is on like another court, my lord. I kindly pass for them.
Why is it for orders? IA,
There is an IA, my
IA for
inter.
suspension,
Yes, no.
madam for your legal aid counsel. You filed objection. Will you like to file objection? Madam, you have filed, Bhuya.
Objection accepted. So, Lordship, I'll be filing.
Oh, you filed your objection? Oh, I is there? Let me check whether there may be an objection also.
Well, there is an objection.
Lordship.
There
There is an objection, you have
there
filed.
is an objection.
You have filed. Yes, when then? Wednesday?
Well.
Objections have been filed in the IA by the state, which is on record, para, on the made on behalf of the applicant. Matter is adjourned to be listed on Wednesday. Miss, then I go to Likhiba. Objection has been filed by the state represented by Ms. B. Bhuya, learned. That's what Ekidor naam to likhi diba. K. Fukan, learned legal aid counsel is present for respond number 2. Okay.
Item 10 and 11.
10 is connected with 11. In item number 11, your lordship directed me to obtain a report of health because medical condition. I've
Yes,
received the report.
what is it?
He's suffering from lordship, cancer, my lord. He has undergone total laryngectomy and is currently undergoing radiotherapy. 30 fractions started on 8/11/2024. He's getting the treatment, you know.
He is getting the treatment.
But if your lordship kindly see my additional affidavit which I have filed,
Hmm.
the photograph page 87 onwards, lordship may kindly see.
What is there?
The,
In the IA, in the IA.
Yes, his condition is serious, lordship. He even cannot move alone, lordship. And even then, he
Page?
was page 87, lordship. Additional. 87, 88, and 89. At this stage, he needs care of his family. On medical ground, lordship, he bail may be found.
But he's undergoing treatment, I'm getting the treatment.
Paper book person. Paper book is prepared.
No, Lord. We have prepared one compilation. Paperwork is not.
Objection, etc. Right. To Tuesday, finally. We'll take up the IA for disposal on Tuesday. You come prepared. He's trying to make out a case on medical ground.
My lord,
You have a report, and why you may take further instructions
my lord.
regarding what kind of treatment he's getting.
Okay.
Is there any better treatment which might be available? Or the projection which he is making, whether it's a correct projection. You take instruction on Tuesday, we'll consider, okay?
And regarding other applicants, I will submit on merit for
Okay, this IA is for all the
all,
applicants.
for all.
The report from the jail authorities have been obtained and presented before this court by Ms. D. Bhuya, the learned APP. Full stop. The same has been produced. Para? Para, let this matter be listed for consideration on Tuesday.
Kabla.
You can resubmit this on the next date.
Sure.
I'm not going to photocopy to. It original to file. Photocopy for file in case.
May I pay that one copy may be furnished to us because all the relevant documents are with
Copies of this.
PET.
It can be done, nothing, no problem. Give a copy to him.
Kabla.
Have
Yes, I perform matter to Maridi. Matrimonial. That matrimonial, Mr. Chaudhary, where are you? Yes.
Matrimonial appeal is has been preferred only with regard to a very limited pair. When the application was filed, regard to this maintenance to be granted to the petitioner, this wife, and accordingly that has been allowed by the trial court. But while this granting
By
this
which court?
by the family court, lordship, future,
Family court Silchar.
yes, lordship, their lordship, it is a page number
Family.
45, lordship,
Appeal maintainable.
yes, lordship,
Under which section?
lordship,
Under which section?
section 24, lord.
Of
There is a thing, lordship. The application was filed by
section
the
24 of what?
section 24 of the Hindu Marriage Act.
This is under the family courts.
Yes.
So it will be the family courts act will prevail.
Exactly, Lord.
Which appellate for provision?
The provision on this under section 19 of the Family Court Act.
Read 19.
Not. I am not. Family Court Act, I am not actually carrying that.
See, this appeal has to be under 19. No, there is no other provision for appeal.
Yes, yes,
19 is it does it
Provision.
provide for appeal for an order of this nature?
Yes.
Huh?
Yes.
Please read. Take our family court act. What is the expression? What are the what does 19
No,
say?
this no appeal shall lie from a decree or order passed by the family court with the consent of the parties, provided that nothing in this subsection shall apply to any appeal pending.
No.
Yes.
Provide the consent of the party. Why don't you read the second part? Or
Or from an order passed under chapter 9 of the Code of Criminal
of the
Procedure.
Code of Criminal
Yes.
Procedure. So this is under chapter 9 of the
No, Lord, kindly see the application.
application was under what?
Yes, I'm just referring to that application. It is at page number 20.
Not under 125.
Yes, Lord, you kindly see the application. It is under 24 of the Hindu Marriage Act, annexure 3,
In essence, what would be the difference?
29. Because during pendency of the divorce proceeding, they filed an application under section 24 of the Hindu Marriage. So So in that view of the matter, the provision of maintenance is there under section 24. Now the only this relevant provision is that lordship, the major son, because two sons are there. With regard to one son, there is a finding of the Senate court below that since he has attained majority, so he is not entitled for this maintenance.
Let us see the application. Where
Lordship, it's page number 29, Lordship.
29.
Penalty light maintenance.
Maintenance penalty light.
Yes, Lord.
Read 24 to structure, please. 24 what has 9.
Maintenance penalty light and expenses of proceeding. There's the provision under 6.
What are your grounds?
Lordship, basically on two grounds. First of all, this learned trial court,
You are the husband.
I'm the husband, Lordship. While ascertaining this particular amount of maintenance, did not take note of the fact that this petitioner, whether he is in a position to pay that amount or not. This is the first part. Second part, the vital part is that he has, this family court has passed an order, thereby directing the petitioner to pay maintenance to the son. Now, while passing that order, if your Lordship kindly see
What is the total amount?
this 27,000, Lordship.
Total.
Yes. If your Lordship kindly see the relevant portion,
27,000, is it divided?
this 12,500 to the son and 15,000 to the wife. That means the petitioner in with regard to that particular application.
Son, you say is a major.
Yes, I've annexed that particular document. He born in the year 2005, Lord.
Hmm?
He born in the year 2005. And even while passing this into an order, this learned code,
Is he independent? He has an independent source of livelihood.
no, that aspect is not there. But while coming to the aspect of not granting maintenance to the other son, if your Lordship kindly see page number 50, this
15,
50, Lordship.
50.
Yes. Because the respondent also filed an application under Domestic Violence Act. And in this particular domestic violence case, she has been granted maintenance to be paid by the petitioner. Now, in this page number 50, Lordship, from the middle portion,
Hmm.
it has been mentioned. It also appears from the order dated 4/6/2022, passed in Ms. DV case number such and such. That the
50,
learned
page 50, where?
50, Lordship, from the third line from top.
Okay, it also appears.
It also appears from the order dated 4/6/2022, passed in Ms. DB case number such and such, that the learned magistrate awarded interim monthly maintenance of such and such to the petitioner and 1,500 to her minor son Abhishek Nath, on the ground that the elder son Anirban Nath already attained the age of majority during hearing the learned amicus curiae. So that finding is there since he has already attained the majority. Now, while with regard to the other son, that relevant aspect of the matter which has been agitated for the consent court, that was not taken into account. Even I have annexed a relevant document, Lordship. It's the cross-examination of the.
Now, regarding the age, there may not be any dispute. Let us see what is the consideration for giving maintenance. What about the other son?
Other son, he is also studying, Lordship.
No, what is the amount given to him?
This page number,
Two
Fif-
sons, you have got
two sons. On with regard to one son, Lordship, this the minor son, which has been projected as minor, although he's a major. He has been granted a maintenance of rupees 12,500.
Abhishek is the elder. He
Abhishek is the younger son, Lord.
Abhishek
The Anirban Nath is the elder son, Lord. And Anirban.
younger.
And Anirban Nath, Lordship, is the elder.
Anirban.
Onir-
And this amount of 12,500 is given to whom?
Given to Abhishek.
Abhishek.
Yes.
Now he has also become major.
Exactly, Lord.
Where is the this
The cross-examination, if you Lordship kindly see the cross-examination, page number
this
40.
order which you are showing part of it at page 40 is of which date? 29/6/2024.
Yes, Lord.
Now how come he has become immediately major?
Lordship. I'm
This-
referring to page number 40, Lordship. In the
No, this
cross-examination.
order which you are referring, that
Yes.
one was a major, one is a minor.
Yes.
And minor was given some amount. That order was passed on 29/6/2024.
Yes, Lordship.
When did he attain majority?
This, if it is the 4th of May 2005 is to be taken into consideration, Lordship, then in the year 2023, he has attained majority.
But this was already done 29/6/2024. Maintenance was already given to him.
Exactly, Lordship. That relevant aspect of the matter has not been discussed by the learned court below, Lord. And that is the grievance that's why we have preferred this appeal. Lord.
Now, which is the impugned order?
This last, the annexure, Lordship, starting from page number 45.
No, the order of the DV was of which year?
Order of the DB. It is at page number 50, Lordship. 51.
That was 4/6/2022. Why don't you say that? 4/6/2022, the assessment was made of younger and elder. One was refused, one was, and after
I'm
24.
not challenging that order, Lord.
Understood. You're trying to make out that when in 2022, elder one was not given because he was a major. In 2024, the younger has also become major, so he should not have been given.
Exactly.
And the press order is of 24, the
Twen-
RD order is of 22.
2020.
Say that. What about the dependency factor?
Dependency factor, Lordship, is
Is he
Deputy-
independent?
Ah.
What do you do?
I'm a doctor, Lord. But my financial condition, I can understand, Lordship, but the fact is that my expenses are also there, which I've narrated. But
You're
Apart
paying,
from that, Lordship, this
are you
27,000.
paying to somebody else?
It's not like that, Lordship, but the adjudication part is not there. What
Are
I'm
you
submitting
paying some-
emotionally, I can
No, it's
understand
not a
this.
question of emotion.
Yeah.
Are they dependent? Are they independent? Are they earning anything?
Not to that extent, Lordship, but the wife is having
See,
some.
this is a very kind of thin distinction, 18 plus major. So it doesn't mean that he starts earning.
But the provision is with regard to
Why,
the.
why have you come to the appellate court? As a father. You're not challenging so far as the wife is concerned.
No, I'm challenging both the thing, Lordship, but I'm just pressing for the stay with regard to the son, Lordship, because he has attained majority. So with regard to that, I'm just pressing for the stay order so far as the son is.
You
concerned.
want your son to starve.
No, I'm not saying about that. He can come to me. He's not coming to me. He's staying with his mother. There is no objection on the part of the father. And there is no reason for not staying with the father, Lord. Just putting pressure.
You want to you want to punish your son.
It's not like a case of punishment, Lordship. There's
Punishment.
the
He's not
bonding is always there, Lordship, and I'm ready to take back my son.
punishment
I'm the
and
petition.
portion.
No, Lordship, it's not like that. I'm ready to take back my son, but they are not coming. At the same time, they are putting some sort of undue pressure
You
upon-
presume that your son is in the hostel.
Lordship.
You presume that he is in the hostel. He's abroad, he cannot come back. But he has to leave. What do you do?
No, presently,
He presumes that
Yeah.
your son is in England. He cannot come back. Studying.
so the scenario is defined, Lordship. Defined scenario.
Can you
the
abandon your son
plea-
like
plea
this?
will be defined, Lordship.
Can you abandon? Just imagine.
No, it's not a case of abandonment, Lordship. But the
Yeah.
fact is that what the petitioner is asserting or the petitioner is
Why
agitating.
do you want to stay? We may admit it's a matter, it's a statutory appeal, but why do you want to stay? Pay for the time being, let them come. Stay will not give a right signal.
No, but the fact is that, Lordship, this aspect, the relevant aspect which is required to be taken by the concerned court, that has not been accepted, Lord. Because the major, I can understand, I'm having, being a father, I'm having the
We have
responsibility.
understood. We will take this as a point as a point of merits in the appeal. And that is a debatable issue. Major but not earning, non-earning, dependent. And the margin is very less, just above 18. It's not that 24, 25, still not earning. And
Lordship may,
your financial position is also a very relevant aspect. Had you been maybe earning hand to mouth, living hand to mouth, matter would have been different. And 27,000 is not something extraordinarily high for your wife and two sons.
no, I'm not saying that 27,000 is high, but the fact is that how it has been determined, Lord. The
If you
procedure
think
of
that it is-
determination of
if you
the,
think that is not high, don't press for a stay. We admit the appeal.
because.
We
Lordship,
admit the appeal.
Yes.
Heard Sri S.P. Chaudhary, learned counsel for the appellant who has referred this appeal against preferred this appeal under section 19 of the Family Courts Act against a judgment and order dated so and so, हाँ, देख लीजिए. Para, admit. Para, call for the, this is the final order.
Yes, Lordship, this is the final order.
Call for the records. Para, let steps be taken for service of notice upon the sole respondent by registered post with AD on both the addresses mentioned in the cost title.
Yes.
Steps within 3 working days. In the IA also, IA will issue notice.
Yes,
okay?
Lord.
In the IA, okay, heard 3 so and so, huh? And counsel for the applicant who by means of this application has prayed for stay of the judgment and order dated so and so passed by so and so. The connected appeal has been admitted today. Para, let notice be issued, returnable by 6 weeks. Let steps be taken. Baki sab huh?
Obliged, Lordship.
But the on maintenance part, son is not a party here. He was not a party there.
Yes, Lordship, he was not a party.
But his prayer was made. When was it instituted? Is a maintenance penalty light?
Yes, Lordship.
When was the application filed?
Application was filed on 35/2022, Lordship, page
At
number
that time, he was a minor.
22. Yes. That thing.
Now, this will affect his right. I think you need to file a leave application also. You add him as a party.
No, he was not a party in the original proceeding, Lord.
Understood? You have to file a
Because
leave
the mother
application.
represented the son.
Now, since he has
When
become
the
a
order was passed, he has attained the majority, but that aspect of the matter was
Mr.
not
Chaudhary, if
disclosed.
you do not even listen to us,
Yes.
go on.
Sorry, Lord.
We have understood the issue.
Yes, Lord.
You may have to file a leave application to add
Sorry.
him as a party in the appeal.
I'll do that.
Because he has become a major, he has a right to defend himself. And since this order will definitely affect him, since he was not a party in the original proceeding, you cannot straight away
Before the next date, Lord,
make
by
him,
that.
you file a leave application, will grant leave to
Yes.
make him a party. But why don't you sit and talk and settle matters? So far as your marital issue is concerned, that's a different matter. So far as this issue is concerned, sit and talk and
Okay,
settle the matter.
I'll take care of it.
As per the last order, Lordship, service report,
Item number 12.
yes,
Madam, you are for whom?
is it
For that Kamar, okay. What is it, madam? Oh, yeah.
Lordship serve the notice on the informant. Mujibur Rahman.
Poxo matter?
Yes.
No, nobody has appeared. Okay. Oh. Pursuant to the last order, it is 7/11/2024, whereby further time was granted to verify the aspect of service of notice, comma, Ms. B. Bhuiyan, learned APP, has placed before us a communication issued by the concerned Mikiribheta police station in the district of Morigaon regarding
Date is not mentioned.
on the date we have not said from on the aspect of service of notice. Full stop. Para. Notice is we accordingly accept such service. Full stop. Para. Since the respondent number 2 has not appeared, we appoint. Shri Arunangshu Dhar, learned amicus curiae, to represent the respondent number 2. Let the name of the amicus curiae be reflected in the cause list. And paper book has been prepared. Records have come. And after preparation of the paper book, copies thereof,
LCR is there, my lord.
copy of the same can also be furnished to him.
Dr. Bhargava, I would like to pray for a date for bail hearing.
Aye.
Yes, sir.
Proposition that is there.
In the IAU, right?
Occupation of the-
Um, This court has appointed, this court on consideration of the communication regarding service of notice upon the respondent number 2 has appointed Sri Ankit Arunangshu Dhar as the amicus to represent the said respondent number 2 para on the prayer made on behalf of the applicant. Let this IA be listed for consideration when? Friday next?
Lordship, 9th or 10th of December,
10th I have it.
maybe
On
9th, Lord.
9th of December 2024, name of Sri Edhar be reflected in the cause list. Madam Begum, you are not on record. Are you on record?
May I please your lordship? Lordship, with regard to item number 13, the answer notices, my lord, has come back. But my lord, I have seen with regard to item number 14, with regard to same informant both of the parties, 14, the service is complete. 14 is represented by,
And this is connected.
connected,
Has anybody appeared?
Please do to matter.
usual to me,
Not required.
not with,
Okay. Records have come,
my
Was it?
paper book prepared.
No, my lord.
no, as
Uh,
the objection is
But in the
not
IAM, the objection is not filed.
Okay.
filed.
Objections filed.
With regard to, my item 13, objection is not.
In the other one you have filed,
No, my.
not filed. You like to file objection?
Yes.
Lord.
Are you pressing the IA?
Can press the IA after preparation paper.
Okay.
So then.
Then the
No,
question of filing objection may not
I
come.
can file
They can
objection.
file in the meantime.
Uh,
Well, we'll be
Um,
pressing on the ground of sanction,
Okay. On the ground of
my lord, because they're policemen.
Please.
sanction under what?
197.
197.
Yes.
But Lordship, they are in personal capacity, Lord.
Patrolling.
If
My lord, that is different aspect, my lord.
whether we
different
can represent it or not, if they are in personal capacity.
Okay.
My lord, 13 and 14 both are IS are there. I may be kept open and my lord, they may file the objection because I am not pressing on second match. They will be,
We need to take steps.
because my lord, on that day, they were on, though they were in uniform, but not on personal duties, but acting, they were on that area. If it's Nakasik,
Cannot.
Your clients.
Yes.
actually, we all were together. So the issue is.
What is
that
the offense? 302.
302. But according to the sanction is required, but my lord, with regard to going to the record, I don't think so. The sanction will be an issue later
Why?
because my lord, the was that though they were on the duty, my lord, on that area of this, but while committing the offense, my lord, they went out of their area to personal capacity, though they were on uniform. So my lord made
Not a part of the,
the sanction was.
materials may not reflect that they were in discharge of duties.
Yes, because sanction part was discussed by the learned trial court. Also. So my lord may not be the issue later on.
Okay, we'll not say anything now
Anything,
then.
my lord, may give you,
Okay.
but only the IAM.
The objections are yet to be filed. Para, on the prayer of Sri K. Das, learned APP, 3 weeks time. Further 3 weeks time is granted to enable filing of objections. You write in the IAs, okay?
Okay. No, the step of it, like, step, my lord, the respondent in their personal capacity as party respondent. They have to take steps, my lord. My lord, 13, with regard to item number 13, unserved notice, about 14 service is complete. So my lord, the
Sir,
same
just
information.
because-
Unserved notice, then they have to take steps, your lord. The personal capacity, they have to pay the party respondent.
Equal to matter, my lord, and 14.
Why did you services should not have been made, ordinarily, 14 of service completed. Same information. Same information.
Oh, same.
Same info, they are the same.
Information I have
parties.
seen
Okay,
myself.
we have not passed anything, maybe on the next date.
Because the record,
Intermittent.
in services complete in the IF file by.
No, if they had appeared, then we would have
Oh.
asked the learned council that you can appear in both the cases. Since they have not appeared,
Yes, my
matter
lord.
is still fluid.
My
We'll
lord.
see on the
My-
next date,
my lord.
okay? Yes, next. 15.
Yeah, Trigger.
Yes, go ahead.
Item 15 is appeal against conviction lawsuit
Hmm.
for the first time.
There is,
I for bill for the first time come.
you have filed IA for bail.
Yes.
It comes for the first time.
Yes, sir. What is
Ah,
POCSO is there.
okay. Heard Sri D. Gogoi Learned Counsel for the applicant who has filed this application under so-and-so, I immediately 430 so-and-so. Something like this for release of so-and-so. Let note, the para, the connected appeal. Criminal appeal 340 of 2024 has been admitted. Admit Quran item. It was not admitted.
Not
We'll take up the appeal first then.
Yes.
Why the IA? You are the new council, okay,
Yes, Lord.
okay. You write in the appeal. Heard 3D Google Learned Counsel for the appellant. How many appellant? One.
one appeal.
Appellant who has preferred this appeal under so-and-so against so-and-so पूरा लिख दीजिए हाँ first title से let don't say let admit para call for the records, let steps be taken. Sri K. Das, learned APP, accepts notice on behalf of the state respondent. Let steps be taken for service of notice upon the respondent to in the manner prescribed, which is to be routed through the office of the public prosecutor Assam. Steps within 3 working days. List after 6 weeks for service report as well as report on receipt of records. And in the IA, same, huh? Pehla jo hai, this IA has been filed for under so-and-so. The connected appeal has been admitted today. Para. Let notice be issued, returnable by 6 weeks. Sri K. Das, same hoga. Then respondable to same service through the office of the PP. Also, take. Objections may be filed if so advised.
Hello. In item number 16, my lord, they have filed objection, my lord, for the service. Put it
Who has filed objection?
in the IA, they have filed objection, my lord.
The state has filed
Yes,
objection.
yes, lord.
The private respondent has not appeared. Service complete or not?
I have not received any information regarding that, Lordship. I have unable to communicate because.
Okay, get the instructions.
Lordship, one.
Okay. Though objections have been filed by the state, comma, Sri K. Das, learned APP, Assam, praised for, and is granted 3 weeks' time to obtain instructions on the aspect of service of notice upon the respondent to.
Hello.
Item to you on supply list.
Please, your lordship. This service with regard to number 2 is complete, sir. And there is a IL also for sentence.
This is for POXO.
Last.
I could. One is entered appearance, lordship, and.
We will appoint a amicus. In the IA, you file objection?
Not yet, Lord.
Not yet.
Need to file an objection.
Where is the service report?
Lordship, there's the office note, it is 6/10/2020.
You know, the order is also there.
All right.
Um, Order dated 8/12/2023 of this court reflects that service upon the respondent number 2/informant is complete. Para, since none has appeared, comma, we appoint Shri Atul Tiwari, learned counsel, learned amicus curiae, to appear on behalf of the said respondent number 2. Para. Let the name of the amicus curiae be reflected in the cause list. Henceforth, full stop. Ms. B. Bhuiyan, learned APP, submits that objections would be filed and accordingly praise for time. Para. List after 4 weeks. List after 3 weeks to enable filing of objections.
That may be
List on, we fix the date.
around 2 years, sir.
List on. Manul, Abhijit, Vice Chairman. List on 13th of December, is it okay? 13th of December. Let it be not 13th, let it be 16th of December. 16th, yes, Monday. Item 17 for hearing.
Met.
17, my lord. A copy of the paper book has just been served on us from the office.
Matter pertaining to 302.
Oh, we talked to-
Yes, 376 and section 4 of POCSO.
POXO is there.
R. Chetri's name is shown. He is also,
Architect is the amicus.
yes, R for R2.
Where is he? Can you,
And I am in custody since 2019.
now both the aspects will be there. We'll grant some time to madam to prepare, but we want the presence of the amicus also. If
Okay,
not, then
okay.
somebody else, but we need the informant to be represented. But for that, we are not going to adjourn this indefinitely.
The
Yep.
coming week, it may take a fixed
But
date.
can you inform Madam Chetri?
Our
Madam
Chetri?
or who? Miss, what?
Mr. R.
Mr.
Chet-
Who is our
Is it-
Chetri?
okay. Wakalatnama, Raji Chetri. Wakalatnama file.
আছে নেকি নাম্বাৰ? এইখনত থাকিব নহয় নাম্বাৰ এইখনত। নাম দেখা নাই কিন্তু মই Chetri মন কৰা নাই। Do Sri A. Ahmed, learned counsel for the appellant is no, heard Sri A. Ahmed, learned counsel for the appellant, para. Ms. B. Bhuiyan, learned APP Assam, however, submits that copy of the paper book has been recently furnished to her and she accordingly prays for some time. Para. We have also noticed that though the respondent number 2 is represented by a legal aid counsel,
No, Lord.
amicus,
No, he entered privately.
a private counsel is represented by a counsel within bracket Sri R. Chetri, comma. There is no representation today. Para. Considering the aforesaid aspect and also the fact that the conviction is under POXO comma. The matter is adjourned. To be listed on, we give a date.
Coming week, any date,
Okay. Today is 20th.
2019 matter,
22.
Tuesday,
We'll have it on 3rd December, Tuesday. Okay, you get enough time. And
Lord.
try to inform Mr.
My
Chitti.
lord.
Oh, not an amicus. We thought it's amicus. Now, if the private respondent after private engagement does not appear, then we'll go ahead.
Lord.
If amicus was there, we could have appointed somebody else. Let us see what happens.
So can it be in the last week of November, or the 26th or 27th,
26th will hardly have any time. Only
Or-
2 days.
28 or 29, Lord?
Why? Second, you have a difficulty. 3rd December. 3rd December.
Okay.
You also get some time. you
My
can
lord.
also- How many witnesses?
Here,
Very
Lordship,
few.
interesting issue was there. Here, Lordship, the victim, after recording her 164, Lordship, she committed murder. She was found in hanging position. And in connection with the same, mother of the victim, who is the informant in the present case, she was a suspect that she killed her daughter. And she was in jail for 3 months. And she said that she was informed by her daughter that these things happened, and on the basis of that, he was convicted by treating the 164 statement as dying declaration, whereas that was not in connection with her death. So now issue is that whether 164, which was not in connection with her death, can be treated as
No, what is the proximity of death and 164?
after 1 month.
Dying declaration connection. Was she critically injured or on a deathbed while making
No,
the
that was
statement?
not in connection with the.
No, understood, but otherwise was she in a critical condition that she was about
No,
to die?
no. Even in fact, the mother of
No,
the girl.
treating the statement at 164, simplicity is a different aspect,
That can be.
but
that can be.
dying declaration, madam,
My lord.
I think, okay, we'll consider.
Alright.
Hold on.
Nine, okay? Oh, amicus, okay.
Yeah, Lordship, I am starting today, Lordship, but I will need some more time to go place some judgment. Here, Lordship, there's one issue was there regarding, Lordship, that 164 confessional statement is there. I have those citations, but I could not go through properly. But I will place the case today, and or at second half I can place those citations. I can start now, Lordship, and
How
I
long
will
will it take? We will not try to have a break. If we start, we'll complete it.
Lord.
Because next week we do not know our position.
today I will complete it.
Right.
Here, Lordship, just I'm giving to you date, Lordship. In the present case, Lordship, incident occurred on 9/6/2006.
Just a minute. What is his name? Neem.
Lordship. Neem Toimari. Alias Mohim.
Conviction under
Under section, Lordship, 302.
your amicus.
Lord. Three zero two and 201. Lordship, may kindly turn to page 29
Only
first.
4 witnesses.
Lord.
Okay. Let us come to the Jahar.
Before that, just I'm pointing out one thing, Lordship. Page 29, Lordship, may kindly come to for a moment, Lordship. This is the judgment, Lordship.
Yes.
The incident occurred on 9/6/2012, and FIR was on 6/12/2006. top your lordship will get. And down below your lordship will get that he was arrested initially on 7/12/2006 and he was released on 19/6/2007. Thereafter, he was again taken into custody on 1/2/2010, and since then he is in custody, Lord. And he has already served out for 13 years during trial. And the present judgment was passed on 2022. That is another 2 years. So he is already in custody for more than 15 years.
Yes, please read the Ejaha.
Lord. Page 4.
Hauraghat PS.
Dr. Karbi Anglong. Hauraghat PS.
Please read.
Humble submission is that about 20 years ago, my niece, Srimati Dali Doimari, got married to a person named Neem Doimari, resident of Bahbari, and she had been living with him along with their 3 children. But on 9/6/2006, we were informed that our niece had eloped with someone else. Accordingly, we searched for her, but we could not get any information. It was learned from a certain source that Neem Doimari, the husband of my niece, had confessed that around 10 p.m. on 9/6/2006, he had killed her, my niece, in the house and had thrown her into Sonarijan River. I therefore pray to you to take necessary action upon investigating into the matter and oblige. PW1, your lordship will find at page 9. This is the informant. Mary.
Just a minute. Dead body was recovered,
That body was
not recovered.
that aspect is there that prosecution failed to show with pro circumstance that the victim actually died.
What is the explanation that, lodging of the FIR after a delay
Good.
may be there, but it has to be explained properly.
Accept.
Now, this FIR was, Ejaha was lodged on 5/12/2006.
2000.
Okay, there he says that his niece was married 20 years before, no problem. 9/6, they were informed that niece had eloped with somebody, 9/6,
Right.
that is 6 months
Yeah.
earlier.
Yes.
Then again he says that we searched,
Right.
but we could not get. It
Right.
was learned from certain source that so-and-so had confessed on 10 a.m. on the same date, 9/6 itself,
9.
that he had killed. But even after that, the FIR was lodged after 6 months.
After-
How has
Uh,
it been explained?
He tried to give explanation by saying that initially he reported the matter to the villagers and they tried to ask him and inquire from him. So those process was there, therefore that got delayed. In deposition PW 1,
Let us see PW1.
page 9.
টাইপ মাৰিব লাগে আচলতে ইমান সৰু ফোনখন আমাৰ এইটো ফ্ৰেছ টাইপ কৰি পেপাৰটো যদি বনাইছে 1.5 স্পেচত হ'ব লাগে মিনিমাম PW1 is at page 9.
9.
Informant,
Informant.
Of the
deceased. Please read.
I know the accused person
This
on
was
the top,
before the separation,
before the step. And subsequently it was transferred to the additional.
the judicial side.
Judicial.
Okay, okay. Please read.
I know the accused person on the top. His name is Neem Doimari. He lived at Pagbari, 1 kilometer away from my house. He married my nephew.
My
He is
niece,
my
it should have been niece.
sorry, niece. It should be niece.
It should have been niece.
Yes.
Okay.
He married my niece. He is my nephew's son-in-law. He married my niece. Dolly Doimari about 20 years ago, as per social customs, Thus, they had got 3 children. They lived as husband and wife. Once I came from the villagers that my niece is not available in her husband's house. It will be come to know. On getting information, I went to the house of Neem Doimari and asked about my niece. Then he told that she fled away with another person 1 week back. While I went to the house of Neem Doimari, I saw 3 children of Neem Doimari at home. They also told that their mother is not available at home from 1 week back. Then I returned home. I searched for my niece. I also told my son-in-law to search Dolly Doimari. Thus I searched her. I also searched her of my relative, but thus I searched almost 1 month, but I did not find her. I did not inform the matter at Thana. I decided if I do not find my niece, then I will give বিচার at village level. I told the uncle of the accused about it. The uncle took time for 1 month to find the deceased Dolly Doimari. After 1 month, he told that my niece was not found after searching her. I told the uncle of the accused that if the accused person takes oath that he did not kill my niece before God, then I will not give বিচার at Thana. Thus 1 week passed off. After 1 week, the uncle of the accused told that the accused will not take oath before the বিচার. If necessary, feels he will attend before Thana. Then 2 months passed off. The occurrence took place in the month of June, but I do not remember the year. One day, while I was at Langhing Bazar of my own home, the police caught the accused Neem Doimari and inquired me about the accused person. I told before the police that the accused is my nephew, son-in-law, and he married Dolly Doimari, who is my niece. Police told me that the accused person surrendered before the Thana. Now, here, Lordship may kindly note that here he is saying 2 parts. First, that PW1 saying that police already arrested the accused. And second, Lordship, that he surrendered before the police, because your Lordship will find something contrary in the deposition of the IO, Lordship. He also confessed that he had killed his wife, Mrs. Dolly Doimari, wife Dolly Doimari. He told that he had thrown the dead body of his wife at Sinarijan River. Police told me, as told by the accused, the dead body of my niece was not found. The accused did not tell the reason of killing. I did not go to Thana. I filed an Azahar to police on the spot written by one person. Name is not known to me as per my version. Police inquired about the deceased. I told that she is my niece. Exhibit 1 is Azahar and signature. Police recorded my statement. I could not say about any quarrel with them. Cross. Neem Dewari is a cultivator. He married my niece 20 years back. They had got 3 children also. When I went to the house of Neem Dewari and asked about my nephew, then he told that Dolly Dewari had fled away from home. I did not want the help of law while searching of my nephew. It is not a fact that I have given false deposition before the court today about killing of my nephew. Niece. PW2, your lordship will find at page 10. There it
Vishwanath.
Lord.
Who is it?
He is co-villager. I
Okay.
know the accused person on the dock. His name is Neem Dewari, alias Mahim. I also know Dalim Dewari. She is wife of the accused Neem Dewari. Dalim Dewari is no more. Horkeswar Gwari at the time of occurrence incident was at Langhing Bazar. My house is situated about 1.5 kilometers away from the accused house. The occurrence took place in the year 2006. Date I could not remember. At the time of occurrence, I was at cultivation field. At that time, daytime, at about 3 p.m., which is about half kilometer away from my house. My wife, Srimati Mohanty Basumatari, was also with me in the field. At that time, OC Dokmoka PS with his staff and the accused came near the cultivation field and called me to Sanajan River. On inquiry, the accused told that his wife was killed by him before 6 months and thrown her to the river. Police
Just a minute. On inquiry, this is inquiry by whom? Him or the by police?
That is not clear, but the accused was brought by the police.
Police. Police inquired me about the fact. I told the police that I heard the information. Very badly recorded deposition. Very badly recorded. Everywhere you can get two interpretations. See, the second line, as it gives an impression that this was divulged to him, and later on he has shared this information with the police.
Lord.
But why should you not get the benefit? Police inquired me about the fact. I told the police that I heard the information.
But one thing is clear that at the time, OC Dokmoka PS with his staff and the accused came near the cultivation. The police was there. And he was in custody of.
I told that I heard the but I could not. This PW2 will neither be here nor be there.
Lord.
What is it there in the, is anything in the cross? Nothing.
Nothing.
The aspect of extrajudicial confession may come in from one line. But normally otherwise he appears to be a hearsay witness.
Yes, yes. But if the accused was in custody of police, then that will probably not come.
That will not, even that extrajudicial confession will be
Will
barred. But why will the police again ask him, what information was shared to you?
That aspect is there.
Let us proceed, that is an extrajudicial confession, let us see corroboration.
That judicial confession is there.
Judicial
Judicial
confession,
Yes, sir.
confession is,
oh, it's with,
yes.
But
yes, please.
PW 3, page 11. Gunadhar Kanta, Gunadhar Kanta Sharma.
Gunada Kanto.
Gunadhar Kanta. On 7/12/2006, I was working in Tipu as magistrate first class. On that day, accused Nim Doimari, alias Mahim, was produced before me with a prayer for recording confessional statement of the said accused under section 164 CRPC. Prayer was allowed. I took up for recording confessional statement of the aforesaid accused person. Exhibit 3 is my state order. Exhibit 3(1) is my signature. Thereafter, I explained the matter of confession to the accused person named above. That apart, I also cautioned him that I am not a police officer, but a magistrate, and that he is not bound to give confessional statement. If he did so, it would be used as evidence against him. Thereafter, the accused was given 2 to 3 hours for reflection. During the reflection time, the accused was kept in a room attached to my chamber under supervision of my office peon. On completion of the reflection period, the accused was again produced before me. I again explained the matter of confession to him. I also cautioned him again that he was not bound to give confessional statement. If he did so, it would be used against him as evidence. In spite of that, the accused intended to give confessional statement. Finding the accused voluntarily intended to give confessional statement, I proceeded for recording the same. Exhibit 4 is the confessional statement of the accused. Exhibit 4(1), 4(2) is the signature of the accused person. Exhibit 4(3) to 4(7) are my signature. Exhibit 4 also contains my certificate, wherein I certified that confession given by the accused was voluntarily made. The accused confessed before me that on the night of occurrence, he gave kick on the deceased, as a result of which she died. After completion of recording a confessional statement, I sent back the CR and to original court. Exhibit 5 is my order. Cross. In the room where accused was kept for reflection, there was no police personnel. Almost 3 hours were given to the accused for reflection. Here, IO is page 13.
1-3.
Yes, 1 page, PW 4. On 5/12/2006, I was posted at Dokmoka Outpost as Assistant Sub-Inspector. On that day, one Sri Harkeshwar Goyari filed a Ejahar before the IC of the Dokmoka Police Outpost. The complainant brought the accused Nim Doimari along with him to the Dokmoka Police Outpost. Accordingly, IC of Dokmoka Police Outpost, Sri Jayanta Kolda, received the Ejahar by Dokmoka OP GD entry number 6 dated 5/12/2006 at 6 p.m. Forwarded the Ejahar to the officer in charge of Hauraghat Police Station for registering a case under proper section of law, and he informed officer in charge of Hauraghat Police Station that ASI KC Nath already taken up the preliminary steps of the case. Accordingly, officer in charge of Hauraghat Police Station received the Ejahat and registered a case at Hauraghat Police Station by Hauraghat PS case number 139 of 2006 under section 302-201 of IPC. Signatures. Then I examined the complainant at the Dokmoka police outpost. I have also interrogated the accused Nim Doimari at the Dokmoka police outpost. During interrogation, the accused Nim Doimari confessed that he killed his wife Dolly Doimari on 9/6/2006 at about 10 p.m. and thrown the dead body to Sunarijan River. As the date of occurrence was 9/6/2006, the complainant filed the Ejahat on 5/12/2006. I went to the place of occurrence on the next day morning of filing the Ejahat, and I searched the Sunarijan River for the dead body. But I have not found the dead body of Srimati Dolly Doimari or any clothes from there. Then I prepared a sketch map of the place of occurrence, that is Sunarijan. On 7/12/2006, I forwarded the accused Nim Doimari to the Honorable Court and prayed before the Honorable Court to record the confessional statement of the accused Nim Doimari under section 164 CRPC. And accordingly, the Honorable Court recorded the confessional statement of the accused person. As my preliminary investigation was completed, I handed over the case diary to the officer in charge of Dokmoka Police Outpost for further investigation. Sri Jayanta Kolita completed the investigation of this case and he filed charge sheet of the case against the accused Nim Doimari under section 302-201 of the IPC, as he found sufficient materials against the accused Nim Doimari to be involved in this case. Sri Jayanta Kolita has already expired, so is the charge sheet. Cross. The complainant has not mentioned the reason for delay in filing the Ejahat. I have not mentioned the name of the village in the sketch map. So this is the evidence. Identify if your lordship kindly turns to page 21 to the question number 15. He admitted that he made the confessional statement. That is there, page 21, question number 15. Now, my submission of your lordship is that there are two aspects. First,
Let us read the confession.
lordship, that your lordship will find page 68. And the statement your lordship will find at page 72. My name is Nim Doimari. I am a resident of Bahbari Langhing. Around 9:30 p.m. on 9th June, I assaulted my wife Dolly Doimari and also kicked her for 3 times because she used to quarrel with me. That day, I had consumed some liquor. After the quarrel, when I kicked her for 3 times, she died. At the time of incident, my children were sleeping. When I came to know that my wife had died, I carried her dead body on my shoulder and threw it into Sonarijan River, which is nearby. From then on, I did not go there to see it. After returning from there, I slept on my bed in the night. Out of fear, I did not inform anyone about the incident. When the members of my wife's family inquired about her, I did not tell anything. On 5/12/2006, I came to the police station and confessed everything before the police as to whether I had killed her and in which place of the river I had thrown the dead body. Police arrested me and produced me today. Now, this part, Lordship, that on 5/12/2006, he went to the police station. But if your Lordship see the evidence of PW4, that is IO, he said that complainant, before complainant, he confessed and thereafter complainant brought the accused to the police station. PW4, Lordship, may I kindly see. Fourth line, page 13. The complainant brought the accused Neem Doimari along with him to the Dokmoka police outpost. And the complainant says, Lordship, that police already arrested the accused and thereafter went to his house to inquire about the same.
Yes, there is no inconsistency as such. 5/12 in his confession statement, he says, third last line, on 5/12, I came to the police station and confessed everything.
Okay.
Now, what is the version of PW4? Complainant brought him to the police station.
Lordship.
His coming is
No,
proved.
now Lordship may kindly see the statement of PW1.
Is that it? How this should progress?
Now Lordship may kindly see PW1, page 9.
Yes.
He says, in middle portion, your Lordship will find
Hmm.
one day, while it starts with 1 day.
Hmm.
1, 2.
Yes.
11th line of his down below of his
Yes.
chief. One day while I was at Langhing Bazaar of my own home, the police caught the accused Neem Doimari and inquired me about the accused person. I told before the police that accused is my nephew's son-in-law and he married Dolly Doimari, who is my niece. Police told me that accused person surrendered before the Thana.
Which is the date?
That date is specifically not mentioned, but he came to know police that the accused surrendered and he confessed.
Then you see, I did not go to the Thana. I filed an Ejahar to police on the spot. It happened in the same transaction.
But the first part, where he came to know about the surrender of accused, and at that point of time, he was at Bazaar. That is what I was trying to place to.
See, the FIR Ejahat was lodged on 5/12.
Lordship.
There is no problem, page 4.
Sure.
Okay? And you kindly say yes, entry 6 p.m. 6:12. Yes, the date is slightly dicey here because there was an outpost.
Right.
The outpost was Dokmokla.
Right.
It was under Hauraghat.
Right.
So the actual information which was received was in the outpost.
Outpost.
Kindly come to page 5.
Page 5 I have seen.
Received by so and so 5/12/2006 at 6 p.m.
Right.
and forwarded to OC Hauraghat.
Right.
And therefore, if you turn over to the registration part of the Ejahar as FIR, in the first page, you find that the information received is 6/12
6:12.
at 12:50.
Right.
That is when it was transmitted through the Dokmoka outpost. But the GD entry matches. The GD entry is at 6 p.m. of the earlier date.
That I leave up to your lordship, but why I'm pointing out this, because lordship, there has to be legal assistance before recording that 164 statement, lord. Whether that was provided or not, that is not there. Just I'm relying on one citation, lordship, of our High Court.
Legal assistance before.
Yes.
It's
But I have understood, lordship, subject to correction.
legal assistance. Leader or assistant First, you formulate your points, Mr. Ahmed.
Lordship,
Then you formulate your point. This
Lord.
citation will be taking reliance on a particular point.
Lord.
May formulate your point, then we'll go to the judgments.
so here
First point, you are attacking this confession that it cannot be relied upon.
there cannot be relied
Okay.
upon.
That is your first submission.
First,
And to
second submission is that, lordship, that conviction cannot start with confession. There has to be some other material in the case, lord. And in the present case, except confessional statement, there is no other material. That I will place one citation, lordship, to that.
that means you, in other words, you said that confession has to be corroborated by
Corroborated.
other material.
By other material. lordship.
Confession cannot be the sole basis of a conviction.
No, the case cannot start from confession and cannot end in confession. There has to be some other method. In the present case, it starts with the confession and it ends with the confession. There is no other method. Even regarding the death of the accused, there is no death of the deceased, there is no method. And they have to prove it either through circumstance or through direct evidence. In the present case, direct evidence was not possible, so they have to prove it through circumstantial evidence. By adducing the evidence of the those other children who were residing in the house or the other particulars, that is not there.
Okay.
And that death of the deceased, lordship, that is not conclusively proved. That will cover the second part. These are the two.
1982,
Lordship.
TRLG.
Paragraph 17 and 18.
That reference.
Lord.
Yes. Paragraph?
17 and 18. Page 14, down below, Lordship, designation is there.
Yes. Paragraph 17.
So this, state of married. The last element is the confessional statement. We have already stated that the accused was arrested on 14th and kept in police custody till the 17th. The detention of the prisoner beyond 24 hours was violative of section 57, read with section 167 of the CRPC. However, the police tried to cover up the illegality by saying that the accused was arrested on 16th. However, the oral and documentary evidence pointedly show that the accused was arrested on 14th. Hence, the accused was in illegal detention and the police tried to suppress the fact. Therefore, the police pressure was very much there and there was unexplained delay why the accused could not be produced within 24 hours before the magistrate. This creates a reasonable doubt that the police pressurized the accused to confess. The accused also stated in his examination that he was tortured by police. A confession must be perfectly voluntary as well as true. The burden is on the prosecution to show the two elements. When the prosecution demands conviction on the basis of confession, the court must apply double test. Whether the confession is voluntary, if so, whether it is true or trustworthy. Satisfaction of the first test is a sine qua non for its admissibility. If a confession appears to the court to have been caused by any inducement, threat, or promise as mentioned in section 24 of Evidence Act, it must be excluded and rejected. No question of proceeding further to apply the second test arises. It is the sum and substance of new enunciated
Law enunciated.
it is the law enunciated in 1981, Criminal Law Journal 424, Guwahati, Kuthu, Guwala. The object of section 164 of the code read with the judge's rule, that is the executive instructions of the High Court, is to find whether the statement sought to be made by an accused is perfectly voluntary or not. The requirement of observing the mandatory provisions contained in section 164 and the rules is to find out the voluntariness of the statement. A magistrate, before recording a confession, must make inquisitorial inquiry, make adequate exercise to ascertain as to whether the accused was compelled by any external element or to compel to make confession. The magistrate must exercise to find out the real motive behind making the confession. If he finds the motive to be well grounded, that is, the prisoner has a real, genuine, and impelling motive to make a clean breast of his crime, the magistrate should proceed to record the confession. We have dealt with elaborately as to the duties of a magistrate before recording of a confession in 1981 Criminal Law Journal 430 Guwahati, Gendra Burma versus State of Assam as well. We reiterate that the provisions of Section 164 and the judge's rule are a safety valve made to muzzle involuntary confessions. It has to be held in the said decisions that the warnings set forth in Section 164 are merely illustrative and not exhaustive. One of us, Justice Lahiri, observed in Kuthugwala Supra and Gendra Burma Supra that it is imperative for the magistrate to explain to the accused his confessional rights under Article 22(1) of the Constitution as well as the provisions of Section 303 of the Code about his right to consult a lawyer before recording any confession. So that was not there in the deposition. It has been held that even at the stage, at the investigation stage, an indigent accused has a right to free legal aid. The importance of legal aid to an indigent at the investigation stage and particularly when the accused is produced for making confession was highlighted in the aforesaid decision. It has been held that failure to provide free legal aid to an indigent is violative of the basic and fundamental norms of justice, and no court of justice ought to act upon such confession. One of the ingredients of fair procedure is providing free legal aid to the prisoners who are indigent or otherwise disabled from securing legal aid. We rely on the observations of Professor Venci Yele Gideon, and so quotation is there. The right of the under trial prisoner to the assistance of a lawyer provided at state cost is secured to him. In the constitutional right of every prisoner who is unable to engage a lawyer or secure a legal service on account of poverty, indigence, or incommunicado situation to have free legal service. In default of compliance of the obligation by the magistrate, the confession is vitiated as contravening Article 21. Should I read further?
Yes.
So in the present case, what I have found from the paper book, Lordship, he was not provided with the assistance of lawyer, subject to what my learned friend says from the record, Lordship. And I'm relying on another section. I'm sorry, Lordship, I could not plot it, Lordship.
Here, paragraph 20 is on also another consideration.
Good.
The question was not proper because he was not in that case, that death reference case, Ravindra.
Good.
He was not made aware of the consequence of making a confession. That was something which was also confronted the court. Please read 20
Yes.
while putting questions.
While putting questions, the learned magistrate posed some questions, and one of them read, "If you do not confess, I will not punish. I will not punish you. I cannot punish you even if you confess. But if you confess, your confessional statement will be used against you. Have you understood me?" We fail to understand what the learned magistrate meant by "I cannot punish you even if you confess." It invariably carried the impression to the accused that if he confessed, no court would punish him. Further, the magistrate did not tell the accused that the confessional statement would be used in evidence against him. It is a fatal omission. At any rate, the questions were misleading. In view of the prolonged detention in custody, the slip-foot manner of the recording, omissions to fill in the column required by law to be filled in, and the completion of the entire proceedings of recording confession within 65 minutes compelled us to conclude that it must be adjourned.
Jude.
It was recorded in violation of law as well as norms of justice. Further, the accused was entitled to legal aid being an indigent person, and he was deprived of his constitutional right. On these grounds, we cannot accept the confession as voluntary.
But here. Kindly see the concurring part of Justice Ansari here. Paragraph 23. See, this was the reason, this reasons had come later.
Sure.
Mr. Ahmed, kindly read paragraph 22 first. Paragraph 22 first. For the foregoing
Foregoing
reasons,
We
we
hold
hold
that
the prosecution has failed to prove this case against the accused beyond reasonable doubt. These are the reasons why we allowed the appeal of the accused. Appeal was already allowed. Reasons were forthcoming, so these were the reasons, okay?
Okay.
And we set aside the convention and direct release of wider order. This was an earlier date, 9/7/81. These are the reasons which so rejected the so-and-so. Then see, kindly see the concurring part. I generally agree with what has been stated by my learned brother in his labored and exhaustive judgment. I, however, have reservation about remarks relating to learned trial court and PW2 on the subject of legal aid also. I reserve my thoughts.
Sure.
Okay. So this is not a ratio. Ratio is only to the aspect of that
No.
the aspect of conviction was set aside. That was the judgment.
That another judgment there that on same issue that 1998 Criminal Law Journal.
Page
354. Abed Ali Jamadar versus State.
Hey, you can't tape to anybody's.
Abid, Jamaat. Abed Ali Jamadar. ABED. Ali. Then Jamadar. JAMADAR. Kolkata High Court Division Bench. Starts from page 56 from the submission on this aspect, Lord. Paragraph 56 in my copy. 56. The last point urged by Mr. Mitra. Submission. In urging the above point, Mr. Mitra has drawn inspiration from the division bench judgment of the Guwahati. This judgment was no, in the present case which I am referring, it is division. Yes, yes, that aspect was also considered. That it was not. No, it was brought. But I have read that observation also. Paragraph 62, that aspect which Lordship has pointed out, it may not be out of context to point out that paragraph 60 might be that Ansaria, Justice Ansaria, one of the learned judges constituting that along with other aspects, it has to be seen. Therefore, initially I have pointed out that how he was brought to police station, there is dispute. Because immediately thereafter he confessed. That is therefore I was pointing out that at that point. On 7th. And affair was lodged on 5th. And whether it is Lordship true or not. Because Lordship, the one citation Lordship, that Honorable Apex Court KIR 1957 Lordship, that says that a confession, even if it is held to be voluntary, it must be established that the confession is true, and it would be necessary to examine the confession and compare it with the rest of the prosecution evidence and the probabilities in the case. Even if it is found that it is voluntary, then also that whether it is true or false. Yes, because still that also it is not pointed out by the prosecution that whether actually he died or not. That aspect is not there because from the initial stage, the appellant has said that he loved. That one part is there. That informant himself said, not it? That before the informant, to the informant. Hello. That page 9. No, in the deposition he said, the PW1. No, that is not.
Can we
That is why I have also pointed out to your lordship that how long he was there in custody, and your lordship knows for a poor person to defend in this long period, lordship, it is difficult for him. He was there for 13 years during trial in custody. And otherwise also that regarding that that is there. I do not have any. No. That aspect, lordship may consider that in the present case, the prosecution failed to show that she actually died, because apart from confession, there is no other material to show that she actually died. Because the first duty is the prosecution, that they are charging me with 302. So they have to first establish even through circumstance, Lord, that whether she actually died or Lord, Lord, Lord. That one citation I will place after some time, Lord, that it cannot, the prosecution case cannot start from confession and end at confession. That I will place after. Almost.
Lordship, in a case in hand, your lordship, there are certain circumstances which goes in favor of the prosecution, that the wrong information given by the accused appellant to the informant, that she has eloped with somebody else, your lordship. May I take your lordship to the evidence of PW1, who is the informant and uncle of the deceased, my lord, the PW1, uncle of the victim, page 9. I know the accused person on the dock. His name is Neem Doimari. He lived at Baghbari, 1 kilometer away from my house. He married my niece. He is nephew's son-in-law. He married my niece Dolly Doimari about 20 years ago as per social custom. Thus they had got 3 children. They lived as husband and wife. Once I came from the villages, came to know from the villagers that my nephew is not available in her husband's house. My niece is not available in her husband's house. On getting information, I went to the house of Neem Doimari and asked about my nephew. Then he told that she fled away with another person 1 week back. This is a wrong information given to the informant. While I went to the house of Neem Doimari, I saw 3 children of Neem Doimari at home. They also told that their mother is not available at home from 1 week back. Then I returned home. I searched my niece. I also told my son-in-law to search Dolly Doimari. Thus, I searched her. I also searched her with my relative. Thus, I searched almost 1 month, but I did not find her. I did not inform the matter at Thana. I decided if I do not find my niece, then I will give Bichar at village level. Lordship, is a general perception of a villager, my lord, because the allegation given by husband, she eloped with somebody else, my lord. Then thus I searched almost 1 month, but I did not find her. I did not inform the matter at Thana. I decided if I do not find my niece, then I will give Bichar at village level. I told the uncle of the accused about it. The uncle took time for 1 month to find the deceased Dolly Doimari. After 1 month, he told that my nephew was not niece was not found after searching her. I told the uncle of the accused that if the accused person takes oath that he did not kill my niece before God, then I will not give Bichar at Thana. Thus, 1 week passed off. After 1 week, the uncle of the accused told that the accused will not take oath before the Bichar. If necessary feels, he will attend before Thana. Then 2 months passed off. The occurrence took place in the month of June, but I do not remember the year. One day while I was at Longin Bazaar of my own home, the police caught the accused Neem Doimari and inquired me about the accused person. I told before the police that the accused is my nephew's son-in-law and he married Dolly Doimari, who is my niece. Police told me that the accused person surrendered before the Thana. Also, he confessed that he had killed his wife, Mrs. Dolly Doimari. He told that he had thrown the dead body of his wife at Sinarijan River. Police told me as told by the accused. I did not go to Thana. I filed an ejahat to police on the spot, written by one person. Name is not known to me as per my person. Police inquest so and so. Then in cross, Neem Doimari is a cultivator. He married my nephew. 20 years back, they had got 3 children also. When I went to the house of Neem Doimari and asked about my niece, then he told that Dolly Doimari had fled away from home. I did not want the help of law while searching of my niece. It is not a fact that I have given false deposition before the court today about killing of my niece. And this is the reason why there is a delay in lodging the FIR, my lord. And thereafter, there is an extrajudicial confession given to PW2, your lordship. Page 10. I know the accused person on the dock. His name is Neem Doimari. I also know Dalim Doimari. She is the wife of accused Neem Doimari. Dalim Doimari is no more. Orchestra Goyari at the time of occurrence incident was at Langing Bazaar. My house is situated about 1.5 kilometers away from the accused house. The occurrence took place in the year 2006. That date I could not remember. At the time of occurrence, I was at cultivation field at daytime at about 3 p.m., which is about half kilometer away from my house. My wife, Simati Mohanty Bosumatari, was also with me in the field. At that time, OC Dokmoka PS with his staff and the accused came near the cultivation field and called me to Tanajan River. On inquiry, the accused told that his wife was killed by him before 6 months and through the river. Police inquired me about the lordship, but there are 2 parts. Although police arrived, the extrajudicial confession, there's nothing on record. It was given in presence of police, or that he was in custody or in the vicinity of police station. It was somewhere else in the lordship, in the field, paddy field or something like that, your lordship, cultivation field, and the police was in the vicinity. That was not there, your lordship. It has not come up on record. I told the police that I heard the information. Thereafter, police returned I told the police to hide the information. So that already has heard from the accused person, my lord. Thereafter, police returned leaving me. Later, police recorded my statement. I told that I heard the information about killing of the wife of the accused, but I do not know the reason of killing. My house is situated about half-kilometer away from the house of the accused. There was no relation with him. I also do not know about his wife. Only I knew that the accused confessed before the police that he killed his wife. I also do not know how the dead body was recovered from Sonaijan River with some clothes. It is not a fact. So there's an extrajudicial confession. There's the accused person, and another circumstance, the accused person surrendered before the police. There's another circumstance which goes against the appellant, your lordship. Now, your lordship, the confession statement, he has voluntarily made the confession statement, lordship, necessary, lordship, rules and regulations were followed while recording the statement. Lordship, page 72. Prior to that, your lordship, the formalities have been carried out and fulfilled by the learned magistrate concerned before recording the confession statement. It has come upon record that it was given on his own will, and he did not deny. Lordship, page 70. Yes. In order to right side, my lord, serial number 6. In order to ascertain whether the accused is prepared to make a statement of his own free will, he is next examined as follows. Answer and any further statement made by, I am not a police, so do you know? Yes. Are you willing to give statement? Yes. The statement of Niyam Doimari is it so and so made in a language of Assamese. My name is so and so. I am next to Borokochari so and so. Then your lordship, next page is the confession statement. Page 72. My name is Neem Doimari. I am a resident of Bahari Langing. Around 9:30 p.m. on 9 June. And he signed the confession statement. I didn't find regarding legal assistance, I did not find anything, my lord. I found lordship, but bail application was moved by a lawyer. On what aspect, your lord? On patient, yes, yes. 7. Uh, there is no straight check and formula. Straight. Straight away from the police station, your lord. My lord. Yes, my lord. After arrest is made. Yes, my lord. Yes, my lord. My lord. Okay. But straight away from police station. My lord. My lord. Let us see the evidence of the magistrate. My lord. My lord. Thank you. After my lord. My lord, no cross examination, my lord.
Page 69. Page 69, there is the form which is given by the from the High Court rules. It says that at least 3 hours reflection time should be granted. 2 to 3 hours says, and there is a form. 3 hours. That is there, but in the form lordship, that column is there, that from what time to what time he was there.
Yes,
It depends.
my lord.
Yes, that's it.
My
Hold on.
lord.
Lord.
Fine. না, এনে তো কথা বলা হয় অনলাইনত নাম আছে ঠিক আছে। You are citing this?
Lord.
What is this?
Lordship, regarding that, how it has to be recorded, Lordship. Lordship, kindly see that paragraph 16, 17, and 21. 2008, 1 GLP, 3 AA. Kanchi Chiba.
Madam, you wanted to say something?
Lord.
After you complete, then we will come to you.
Lord.
Okay.
My lord.
You can place in your turn.
Lord.
So regarding delay, it has been explained properly.
Delay.
Delay. None other circumstances.
That
he-
some bichar was going to be held.
Yes.
Then okay.
Yes, Your Lordship. And another circumstances that he surrendered before the police station.
That is not very clear whether he had surrendered, whether he was taken by the informant to the police station on 5th. What has actually happened on 5th?
My lord.
5/12.
Five,
There are different versions.
that Your Lordship. Your Lordship considers this constitutional statement which was recorded as per law, my lord, as per the stipulation and guidelines given by Honorable Guwahati High Court. So it was followed, and in the column itself, it is written, Your Lordship, constitutional page 72,
Yes.
in page 69,
Hmm.
left column, Your Lordship,
Yes.
column number 8. Magistrate shall not accept under circumstances which render delay impossible, records the confession of an accused person immediately the police bring him into the court. He shall be given at least 3 hours for reflection, during which period he shall be given is given being contact with any police of and shall not be permitted to hold conversation with any other person. And it has been followed, Your Lordship, the guidelines.
Next page. Hello. 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 Itu মানে কি? I was taken to itu মানে কি? Where it was taken to. First is the form of the making the work of the station. And then eating and yes, kept it blank and after 13 years he's saying that thing is yet the requirement is of 3 years. How much time was given, it has to be reflected. Madam, we've just detected something, though it was not pointed out by the learned amicus. Kindly come to the form of the confession.
Yes.
Mr. Ahmed 68, please note.
Lord.
See, from the where does it start?
Magistrate should clearly understand the,
That is one part. Now
oh,
from
that is free.
there's 3. Then next number. Confession have to be recorded during the court. Now
Court
there
hours?
on the right side, there are certain blanks which are to be filled up by the magistrate.
Yes.
The accused was brought by the police station before me on where? Time.
Whether in original it is there.
Nothing is there. We are looking into the original also, side by side. This is only a photocopy.
Whether it's fatal, your lordship.
See why it is necessary, because he deposes after 16 years.
Yes.
He cannot depose from memory. He has to depose from records.
Record.
Now records, if you come to the next page, page 69.
Yes.
69, the first left side column where you have pointed out.
My lord.
3 hours for reflection. On the right, there has to be an endorsement. He doesn't even sign here.
No, signature is there down below.
And down below, but here I was taken all blank. I was sent to from so and so. From EF4 to say it. EF4 was sent again. It's into origin from first place number on the sheet. I was taken to
Lordship, 164 has to be read with 281, couple with 463 of the Code of Criminal Procedure.
For the conviction thing, somewhere it has to be mentioned. And then in the form itself, because the form provides the space.
Lordship, we kindly have a look at 460.
Yes, please.
If any court before which a confession or other statement of an accused person recorded or purporting to be recorded under section 164 or 281 is tendered or has been received, in evidence finds that any of the provision of either of such sections have not been complied with by the magistrate recording the statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, take evidence in regard to such non-compliance, and may, if satisfied that such non-compliance has not injured the accused in his defense on the merits and that he duly made a statement recorded, admits the statement. The provision of this section apply to court's appeal reference revision. Now, your lordship may kindly consider the evidence of PW3, your lordship, the magistrate, and whether it was the occasion any injustice to the accused person, my lord. He covered by way of this state once in a substantive evidence.
Either he had used DW, saying, the love Kora was the version.
Although timing
Right, right.
has not mentioned his position also, whether it is settled the prosecution and whether it injured the person.
No, we have seen that he is a person, he was not an illiterate person.
Not,
He could put his signature in English
my lord,
language.
my lord.
Not to talk about thumb impression, not even vernacular, is to write in English. And the 313 statement was recorded much later. He had all the time to either, or not, will not use the term improve, but he had adequate time to set up a defense.
My lord.
That yes, there was some recorded immediately, it was not voluntary, or I did not know what was there. In fact,
No
in
plea was
313, he said yes. We have not even gone to the extent of adducing DW, that his wife has eloped. That version was only on the air, nothing, no substance. But he could have retracted. There is
My
not, there is no
No
retraction,
retraction.
no retraction.
My lord. And regarding non-recovery of corpus delicti or lordship, since the accused is himself admitted, he killed and thereafter, lordship, he thrown the dead body into the river. So killing part, when he admits himself, even if the corpus was not recovered. Although another section should have been added, 201. That's that.
I think 201 is there. There is
Absolutely.
there. Any citation where which confession which has not, which have not been retracted?
Regarding the time period,
No, citation.
no, time period, time factor, my lord.
Time factor, I think
Yes.
we have held
Yes,
that there is no straitjacket formula. In
My
some
lord.
cases, it may be 4 or 5 hours, it may be less, but a reasonable time should be granted.
my lord.
The intern has squared away.
It says Alok, I have not given the citation, Aloknath Datta, State of West Bengal, 2007-12, SC 230. Retracted judicial complaint should be considered in the light of Article 23, which
No, here it is unretracted.
unretracted.
He stands by it.
I know.
What would be the strength? Won't it fortify the stand of the prosecution?
And one Madi Ganga, 81 to SCC 224.
One matter, DB Arunachal bench,
I know.
where one of us were there. We had held this. Time cannot be a.
Yes, I have brought Shankaria judgment also, it was there with me. And Devi Singh. No, sure, can it be on Monday, my?
No, we are closing it. It's a small matter. No? Monday we'll have other matters. Oh.
Roshni may rely on.
He have a limited time. 2005 to 2009, I have to this is the only circumstance against me. Which should be against me. Oh. Yes. And after completion of the PW, had to advise Jyogi and Jyogi to compulsory accept the completion. There is nothing to bind me. I have a chance to come out of it. Did not. Did not. He did a police in police. He took one. Question in 313 was the story of elopement introduced by him.
No, regarding that,
So it has come up from a different witness that they heard that he said that wife had eloped with somebody else 1 week before and did not go to
So
search for.
PW1, uncle of the.
No, it is.
Yes.
It came from some other,
Other
not from the appellant.
Informant.
in
No,
page
in appellant.
17, question number 2,
Appellant in 313, did he say something?
relating to that question was there. Lordship,
Yes.
I can page 17, question number 2.
Yes. Please read.
PW1, Sri Harkeshwar Goyari has further deposed that once he came to know from the villagers that his niece is not available in your house. On getting the information, he went to your house and asked about his niece. Then you told that she fled away with another person 1 week back. While he went to your house and saw your 3 children at home, they also told that their mother is not available at home from 1 week back. Then he returned home. He searched his niece. He also told his son-in-law to search Dolly Doimari. Thus, you searched her. Have you anything to say in this regard? Answer: yes. PW1 went to my house in search of his nephew.
Well, that's all. He does not reiterate the elopement theory.
No, only it says yes.
Lordship, Devi Singh, this is, no, Madi Ganga was the state of Orissa. 81 to SC 224.
Yes, Samir. Which one?
Mati Ganga versus State of Orissa. I have not
Okay.
given a citation.
Please give the citation.
81 to SCC 224.
1981
To SCC 224.
to SCC
I'll read it slowly.
224.
Yes, sir. Para 5. We desire to express no opinion on the question whether the extrajudicial confession made to PW 225 is barred under Section 24 of the Evidence Act. It is unnecessary for us to say anything on this question since we are satisfied that the learned session was wholly wrong in excluding and the High Court was certainly right in acting upon the confessional statement made to the magistrate. The learned magistrate has put to the accused all the necessary questions to satisfy himself that the confession was voluntary. He has also appended the necessary certificate. We do not accept the Jain's submission that the learned magistrate should have been examined as a witness. Section 80 of the Evidence Act makes the examination of magistrate unnecessary. It authorizes the court to presume that the document is genuine, that any statement as to the circumstances under which it was taken are true and that such confession was truly taken in accordance with law. Sri Jain submitted that if the magistrate had been examined as a witness, the accused might have been in position of to show by cross-examination that the confession recorded by the magistrate was not voluntary. In our case, he was examined. Magistrate was examined by law.
Yes.
The magistrate has appended a certificate that he was satisfied that the confession was voluntary. No circumstance has been brought out in the evidence justifying the calling of the magistrate as a witness. We do not find that the circumstances of the case justify any comment on the alleged failure of the prosecution to examine the magistrate as a witness. And finally, the final submission of the learned counsel was that even if the confession of the magistrate was accepted as voluntary, it had not been sufficiently corroborated to justify the conviction of the accused. It is now well settled that in order to sustain a conviction based on confessional statement, it is sufficient that the general trend of the confession is substantiated by some evidence which should tally with the contents of the confession. General corroboration is sufficient by Subramania Kundan versus State of Madras. In the present case, the confession statement refers to the motive of the occurrence. This part of the confession is corroborated by the evidence of PW1. The confession statement refers to the accused having thrown a big stone on the head of the deceased. This part of the statement is corroborated by the medical evidence. In our case, the doctor was not examined. Dead body was not recovered. We think that there was sufficient general corroboration to justify the High Court acting upon the it. The appeal is therefore this. But in our case, the prosecution proved 164 statement, then lordship wrong statement given to PW1 the informant. Surrendering part or lordship was in doubt. It's not clear with whom he surrendered, my lord. And coupled with the confessional statement and that 313 statement. I think it was rightly complete.
Yes. Mr. Ahmed?
Okay, I will come to the
That-
164 statement
No, that,
and
you
to the
wanted to-
form.
You wanted to play Sankhi.
Yes. Before that, I will like to read out the relevant paragraph here, notice. Paragraph 16, 17, and 21.
Of this citation.
Lord. After that, I will,
Take a break.
Yes, yes, please. This is 2008.
Lord, 2008, 1 GLT, 388.
Paragraph?
16, 17, and 21.
Please read.
Paragraph 16.
Hmm.
In Nazir Ahmed's case, Supra, the Privy Council speaking pro Lord Losi,
The thing which to be done in a particular manner.
Lord.
That you can.
Yes. Paragraph 17, Lordship may kindly say. Supreme
Okay,
Court.
there is something else. Okay, please read that part.
In this contention, it was answered that there was no ground for reading the word may in section 164 as meaning must on the principle described in 5 AC 18. There is no need to call in 8 this rule of construction, well recognized in principle, but much debated as to its application. It can hardly be doubted a magistrate would not be obliged to record any confession made to him. If, for example, it were that of a self-accusing madman, or for any other reason the magistrate thought it to be incredible or useless for the purpose of justice. Whether a magistrate records any confession is a matter of duty and discretion and not of obligation. The rule which applies is a different and not less well recognized rule, namely that where a power is given to do a certain thing in a certain way,
the thing
that-
must be
that is
done in
there.
that way, yes.
Paragraph 17, Lordship, that one citation was there of
Yes,
Supreme Court.
Bappa. Mm.
From a plain language of section 164 CRPC and the rules and the guidelines framed by the High Court regarding the recording of confessional statements of an accused under section 164 CRPC, it is manifest that the said provision emphasized an inquiry by the magistrate to ascertain the voluntary nature of the confession. So here no inquiry was made. I will place before your Lordship. This inquiry appears to be the most significant and an important part of the duty of the magistrate recording the confessional statement of an accused.
But the
And-
format says that whether you have been explained, how do you say that no inquiry was made
I will
on
place,
the,
I-
on the voluntariness?
because your Lordship will find that I'm placing your Lordship.
Hmm.
Page 69 and 70, Lordship may kindly.
Yes.
69.
Hmm.
This is the form. These questions have to be asked to the accused. Column number 5, right hand side, Lordship.
Yes.
So first question is that I am not an officer of police but a magistrate.
Hmm.
Now Lordship may kindly turn to page 70.
Hmm.
This question was asked. I am not police. Do you know? Yes. So
Hmm.
that is there. Now second, that is this is not that you are not bound to make confession. So
Hmm.
that question is there. Are you willing to give statement? Yes.
Hmm.
Then that if he does not make confession, it may be that if he does make a confession, it may be used in evidence against him.
Hmm.
That question is not there in the. It was only in the form. And then fourth question: his her should not say any to because other have told him. Say it at liberty to say whether redresses to say. That he should say to say no thing which is untrue, no thing which is untrue, and I sign my name. So those other questions are not there. Only two
But
questions.
you read 6, the left side column.
Okay.
The magistrate should not proceed to record the statement of the accused unless and until he has reasons,
Hmm.
upon questioning him and observing his demeanor, to believe that the accused is speaking and about to speak voluntarily.
Volunteer.
See, these are discretion which are exercised by the magistrate.
Lord.
The questions which have been asked, that I am not a police, do you know? Yes, I know. Are you making a statement?
Lord.
I think the rest of the statement, how?
That part your Lordship will find in the judgment which I am reading in this paragraph itself.
Hmm.
Other thing. May I read the judgment, Lord?
Yes, please.
Second line of the page 7, Lordship. The failure of the magistrate to put such questions from which he could ascertain the voluntary nature of the confession detracts so materially from the evidentiary value of the confession of an accused that it would not be safe to act upon the same. Full and adequate compliance, not merely in form but in essence, with the provisions of section 164 CRPC and the rules framed by the High Court is imperative, and its non-compliance goes to the root of the magistrate jurisdiction to record the confession and renders the confession unworthy of credence. Before proceeding to the record, the confessional statement a search inquiry must be made from the accused as to the custody from which he was produced and the treatment he has been receiving in such custody in order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from a source interested in the prosecution still lurking in the mind of an accused. In case the magistrate discovers on such inquiry that there is ground for such supposition, he should give the accused sufficient time for reflection before he is asked to make his statement and should assure himself that during the time of reflection, he is completely out of police influence. The accused should particularly be asked the reason why he wants to make a statement which should surely go against his self-interest in course of the trial. Even he is contrived subsequently to retract the confession. This is the lordship that question number 4 in the form. Besides administering the caution, warning specifically provided
But
for
Mr. Ahmed, all said and done, you had all the liberty to answer 313.
Sir.
That not to the extent I have not made, but you would have said it was not voluntarily made. Yes, I had made some statement.
Sir.
But it was done under duress. I did not know the consequence.
But
And it was recorded in 2022.
Sir.
His confession was recorded when? 2006.
2006.
2006, 7/12, 2006. After how many years? 16 years.
16 years. And out of 16 years, 13 was he was in custody.
16
that
years.
aspect also has to look into.
No, 16 years simply said, no. If confession goes, there is nothing else.
Lord.
We don't think there will be any substantive material to bind him if we remove the confession part. But he still sticks that 2022, he says that yes, confession was made.
Contents, in my humble understanding, Lordship, subject to correction, that contents of that 164 will come once it is proved that the recording is proper, Lord. If recording goes,
No, even under aspect of recording, he could have said that I was not even given time. I do not know what I have stated.
probably that question.
And a simple thing I have not made. Matter would have been different.
Still, your Lordship can look into those aspects of the appeal.
Had it been a case of retracted confession, matter would have taken a different line. Now we are only on the aspect of 313.
That I understand. And why he want to make that confession, that question was also not.
And we do not know how the death was caused. He said 3 kicks.
But-
Whether
but it is also doubtful whether-
3 kicks would be sufficient in the ordinary course of
Lord.
to cause death. We are thinking whether on the aspect of converting. But that is also not there.
But at the same time, that
How the death was caused.
but
The dead body paper, I think. Yeah, if the body was discovered with some other marks, how the death was caused. Now that is also not there.
but at the same time, Lordship,
And his own statement that he threw the body, whether it was a dead body or the
After
was-
killing him,
that is
Yes.
we do not know
yes.
whether it was a
yes,
dead body or there was some
Yes.
life in it.
Yes,
Unless the body was found, PM done, it was due to drowning or due to injuries caused.
therefore, regarding that aspect also, that doubt remains, Lordship, because whether she died, that aspect is not cleared by the prosecution side, except from confessional state. Because what the citation which I have placed before, Lordship, that AIR 1957, SC 637, it says, Lordship, if it is found that voluntary, then also, Lordship, that whether it is true or not, that has to be seen.
Which one?
AIR,
Did you place earlier? No.
no, Lord. AIR 1957, I will give a copy to the court.
57, Supreme Court.
Supreme Court 637, paragraph 10 and 11.
Name?
Sarwan Singh,
SAR?
WAN
Sarwan.
Sarwan Singh Ratan. Ratan Singh.
একটু বহুত comment
What's the
করে
state of
দিয়ে
it?
থেকে একটু গেস
Yeah.
5 judges are how many bench strength 5 judges or what?
What?
What is the strength of the bench? 5 judges.
That copy I
Sarwan Singh Satish. I can provide the set.
No, sedition is given 1957 Supreme Court 637. এটাও বেতনের বেত করে লেখা নেই কোনো লেখা নেই না হয় নাকি What was said in para 10 and 11? Truthfulness.
yes.
Truthfulness.
A confession, even if it is whole to be voluntary, it must be established that the confession is true, and it would be necessary to examine the confession and compare it with the rest of the prosecution evidence and the probabilities in the case. Three judges. May I read the paragraph? Lord?
No, it's okay. Two aspects, voluntariness, truthfulness.
Yes.
Yes.
Voluntariness
If
is
voluntary-
required,
yes.
even other than the voluntariness, truthfulness
Truthfulness is
has to be
actually
examined
she has died or not.
with the other circumstances.
Other circumstances.
Okay. That's all?
Yes.
Okay. Close to the yes. Close to the Ahmed Amekasa. Be here. Hearing is concluded, then case.
I will give the copy to the court master after.
Yes, yes. Which one? Last one,
The last-
57.
last. Apply.